Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340 or our emergency line is 07712 761 884.
Hello. You are through to the program, The Community and the Law, brought to you by BWTV and proudly sponsored by BWF Solicitors. Today we bring you another exciting conversation, and it's all about employment. What are your rights as an employee, as a worker? Do I have any right? Can my employer do whatever he or she likes? What does the law say I can do as far as my rights as an employee in the UK are concerned? That is the topic for today, and we are looking at this within the framework of the Employment Rights Act 2025. So stay put, call a friend to call a friend, that we are ready to learn. It's all about the community and the law. So we are going to move on to look at review in terms of what people have said, the experience they've been having engaging BWF solicitors. So this is coming through from Akosia. Akosia says that we had an excellent experience with BWF solicitors and cannot recommend them highly enough. After 2 previous visa refusals for my mother-in-law, we were feeling very disheartened. However, Emmanuel and the team provided clear, professional, and thorough guidance throughout the entire process. They paid close attention to detail, addressed all the previous concerns, and helped us present a strong and well-structured application. Thanks to their expertise and support, the visa was successfully granted. This means so much to our family, as my mother-in-law can now finally visit us. Akosia is happy, and you will be next to share a testimony. This is what BWF solicitors stand for, giving you opportunity to smile and to share a testimony with others. So we are going to have a quick commercial break, and when we return, we bring you the nuggets, the quiz, and allow you opportunity to also apply your knowledge to the law and proceed to having a conversation about today's topic. Don't go far. Don't change the dial. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you so much for returning, and thank you for not changing the dial. You are right through to BWTV, and this is your Community and the Law program, brought to you proudly by BWF Solicitors. So today's conversation is about your rights as somebody working in the UK. Your rights. Are you working in the UK? That's the question. Do you know the changes within the employment space? What are your rights? What do you know and what should you know? So that you'll be able to do the right thing, so that you can exercise your right as far as the rules are concerned. So we go to the nugget. The nugget, as you know, is something we bring to you to give you opportunity to tell you what the law is within a particular area of law, and to offer you opportunity to also share your views or thoughts and to apply your knowledge on the law. And so here, as you know, we are discussing employment rights. And so this is about verbal resignation may not be resignation. You know that somebody can just say that, you know what, I'm fed up, I'm leaving, and they go. And the next morning they come and say, I've come back. Why are you here? I've changed my mind. I didn't mean it. Will you say they've left and so they shouldn't come back or they should go? Does that mean they have resigned? And does that mean resignation? So verbal resignation may not be resignation. What does the court say? Employers must always consider the context of an employee's resignation before construing or interpreting it as intended. If it is retracted, it must be seriously considered. So the employers must first understand the context of the resignation, and if the employee changes his or her mind, it must be accepted that they did not intend to resign. The recipient of the resignation should, in the eyes of the reasonable bystander, consider that the resignation was seriously meant and that it was really intended, or that there was conscious and rational effort for the person to resign. Failure to consider the circumstances of the resignation may lead to unfair dismissal. And this is a case from the Employment Appeals Tribunal, and is the case of Umar versus Epping Forest District Citizens Advice. And here it is a 2023 citation. So 2023, the court ruled that if an employee says that I have resigned verbally and they leave and they come back to say that they've changed their mind, or even within a few moments or period of time say that they've changed their mind, that means they have retracted. You have to accept that they didn't mean to resign. You have to consider all the circumstances before concluding that they actually meant to resign. If you don't do that, and as an employer you say that you chose to leave and so don't come back, the employee can take you to court and sue for unfair dismissal. And that is the ruling of the employment court. So you're going to test your knowledge or apply your knowledge on this law. And the quiz is this. So this is the quiz that we want you to apply the law to. So Seidu, and producer, if you can assist me with zooming. Thank you. So Seidu works for a care home as a carer. On 1st of February 2026, he told his manager that he has had enough of the pressure at work and would not want to work anymore from the following day. The manager told him that since he didn't want the job, someone would take over his role. The next day, Seidu returned to work and explained to his manager that he was stressed and didn't mean what he said about quitting the job. The manager told him that since he chose to leave, he was no longer a staff. Advise Seidu. What can Seidu do? Will you say that Seidu cannot take any action against the employer because he chose to leave the job or he quit the job voluntarily? Or you tell Seidu that, hey Seidu, you can bring action for unfair dismissal against the employer because you did not mean to quit the job. Which of the two options will you suggest to Sedu by way of legal advice? Think about the nugget. You cannot rely on verbal resignation to say that the employee has resigned. You have to consider whether they retracted or changed their mind or not. That is the employer. And so this is an employee who has gone through this process. What advice do we give to Sedu? We are the employment advisors. Think about it. And whilst the conversation is going on, we'll come back to you to tell us what your thoughts are by way of answers to the quiz. Thank you. Now we're going to have a quick commercial break. And once we return, we will be zooming in on the topic for this afternoon.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome once again to the show. You are through and you are right there. Just so you know, remember you can ask any question at all you like as far as law is concerned. You can ask questions about immigration, about family law, about employment law, about dispute resolution generally, anything at all that concerns you. Feel free to ask your question. You can ask your question by dialing into the studio number. The studio number is 020-493-493 7345. The studio number is 020-493-7345. That is the studio number. You can phone in once we are ready to receive phone calls. You can phone in to ask your question directly, or you can text your question to the WhatsApp number, which would then be read for us to answer. And the WhatsApp number is 073 99208 99208 468 073 99208 468. That is the studio number. That is the WhatsApp number to text. Now, if again on Facebook and you want to send your message, you can also send it directly to the chat, into the chat, and we will pick it up and read it out. So these are the options you have as far as participation is concerned. So please remember to share, and share. Let the rest know that we are live, we are live, we are live with another interesting conversation: employment rights within the Employment Rights Act 2025. What should you know if you are working in the UK? What should you know as a worker in the UK? So there are four key areas that we are going to be looking at. We'll start by looking at the law with respect to the rights as an employee in the UK. We'll also look at the minimum wage, wage for 2026, minimum wage for 2026. We'll then look at ACAS. What is ACAS? And what can you do if you have concerns? What can ACAS do for you? We'll look at ACAS, and finally, we'll signpost you to the Employment Tribunal website, where if you have to, you can also access if you have to bring a case as far as employment is concerned. So we are going to have a quick commercial break. When we return, we will start the conversation. Remember to share, remember to invite a friend, and remember to participate, especially the quiz that we gave earlier on. We'll be right back. Don't change the dial.
A successful customary proxy marriage application without leaving the UK. Case brief. The client came to the UK in January 2023 as a dependent partner of a skilled worker. Unfortunately, the relationship broke up because her husband had met another woman. The husband reported their relationship breakdown to the Home Office, and our client was sent a revocation letter, giving her 60 days to find another visa route or leave the UK. She met her childhood boyfriend, who had been pursuing her since she arrived in the UK. Challenge. They decided to get married. However, because the time available to her was short, we advised them to ask their family members in Ghana to undergo a Ghanaian customary marriage. The family subsequently contracted the marriage, and it was registered at the District Marriage Registry in Ghana. Neither our client nor her husband was present at the ceremony. In November last year, 2025, she brought her application for us to send to the Home Office. Strategy and solution. Under UK immigration rules and case law, Ghanaian customary law marriages are recognized as valid if the process complied with Ghanaian law, even if the man and woman were not present at the marriage ceremony. We prepared a detailed representation and submitted her application. Process and timeline. She enrolled her biometrics on the 12th of December 2025. Outcome. Our client was granted 2.5 years as a spouse on the 1st of February 2026. Nugget Ghanaian customary law, proxy, marriage, is recognized in the UK, even if the parties were not present at the ceremony. The process must follow Ghanaian law, including registration and certification. Always seek legal advice from professionals who understand the laws of England and Ghana. Facing complex immigration issues? Contact BWF Solicitors today.
Contact BWF Solicitors today if you are facing any complex case or issue. As far as the law is concerned, your go-to place is BWF Solicitors. We are your community lawyers. So thank you for joining us. Our resource person for today is your own Charles, Lawyer Charles. And today we are going to have the conversation. Today I'm wearing two caps. So by each cap is easily, it fits well. Each cap fits well. So when necessary, we'll shift to the hosting cap. And when necessary, we shift to the resource person's cap. So it's all fine. Yes. So you are with BWF Solicitors. You are with BWF TV, and you are with the Community and the Law Show. So you're right as an employee working in the UK. We know that the law that existed before the changes came is the Employment Rights Act 1996. And there are a lot of issues that arose within that law. And so it became necessary for changes to be made. And therefore, on the 23rd of December 2025, the King assented to the new law or the bill which Parliament has finalized. And therefore, we now have a law that is the Employment Rights Act 2025. The Employment Rights Act 2025 seeks to add a lot to the existing Employment Rights Act 1996 and also remove things which were not favorable. Somebody will say the law has been reviewed, and so we have an amended version, which is the Employment Rights Act 2025. So what are the key things that as an employee or somebody working in the UK, you have to know? So we go into the table of content. So producer, please take us to the content page. Now, if you go back to the content page, please. So I want people to understand the key things in that law. So the content, table of content, please. Is that where you are? So then scroll down. So we have the first part that deals with your right as an employee. Producer, can you zoom it a bit for us? Fantastic. So the first part we're looking at is the right to guaranteed hours. As an employee working in the UK for a UK employer, you have a right to guaranteed hours. You know that before we had what we call 0 hours. 0 hours means that you cannot really tell whether you'll be working or not. If you're on 0 hours, the employer can say that nothing for you. So you cannot really plan your life. And that was detriment to most people. And so employees or workers in the UK now have a right to be given guaranteed hours. Guaranteed hours could be 10 hours, could be 20 hours, could be whatever. But at least they know that they have this hour within a week that they can work. And that is what the employer must make available. So if the employer does not make this available, then we know that the employee can take action. But before that, producer, can you go up to the preamble? The preamble, yes. So here, no, here, so if you can zoom for us. Okay, so we have already stated that, yes, the law has now been effected. Let's go down a bit, a little. Yes, there, the B part. And we are also told that it is functional. And therefore, if anybody has any right to assert within this particular law, then from the 1st of January 2027, from the 1st of January 2027, you can bring action within this particular law. So right to guaranteed hours. What does it say? 1, it says that within the existing law, which is the 1996 law, there is 0 hours for workers. And this has now been amended so that employees must have guaranteed hours. So if from next year, your employer says that you are still on 0 hours contract, then you still have to ask the employer that, manager, you know that the law says that I must have guaranteed hours. Why am I still on 0 hours? It's your right, and you have to speak to the employer from January next year. Right. So we move on to the next one. So the first right is you have a right to guaranteed hours. We go down to number 2. Go to 2. 2. Scroll down for us. Scroll down. Keep going down. Right. So, producer, I think what will help us is if you take us to the content itself, the table of content, then we know specific things that we are picking. If you go back to the table, not from here. So table, yes, good. Thank you so much. So we know that your first one, the right to guaranteed hours. Then we go to section 2, shifts. No, producer, just go back up. Yeah. So number 2 deals with shifts. So right to reasonable notice. So with shift, if you click on that, it will take you to that. So that's what we're going to be doing. Good. So under that, it says that every employee must have right to reasonable notice. What do we mean by reasonable notice? An employer must give notice to a worker, and this must be a reasonable notice of a shift that the employer requests or requires the worker to work. If the worker is employed by the employer under a 0 hours contract. So if an employee is under a 0 hours contract, and the employer, of course, under 0 hours contract, we know that you are called to come to work anytime, or even guaranteed hours contract, you are called to come at any time. So in the morning, you get a call from your employer to come and work. But is it the case that you can be called at any time? The law now says that you must be given notice that you have to report for shift. That means if you are not given notice and the employer calls you and you are on holiday or you are dealing with a family matter, the employer cannot say that you refused work because he didn't know that you are going to be called to work. And so when it was the case that you literally have to plan your life to suit the employer, it is no longer the case. The employer must give notice if they will need you for a particular day or for a particular week. Otherwise, they cannot use that to dismiss you. Let's bear that in mind. An employer should give enough notice to an employee or a worker if they want the worker to report for work or be on duty or come for shift if the employee is on a 0 hour contract. So 0 hour contract, you don't have specific limit, but the employer must give you notice if they want you to come to work. Otherwise, they cannot rely on your dismissal of the request, on you saying that you cannot work to dismiss you. We move on to free. So we know the first one, your right to guaranteed hours. We know section 2 deals with your right for the employer to give you time if they want you to come to work if you are on 0 hour contract. The third one, which is section 3, and producer, please take us back to the content page. Today, you're going to be doing a lot more of that. So right to payment for cancelled shift. Wow. So this is pretty good. Right to payment for cancelled, moved, or curtailed shift. Imagine you have been asked to report on shift. You've prepared. You turned up to work and you are told that we are sorry, you have to go back home. You must be paid for that. Or they call you to come for shift and then they call you again to say, we are sorry, we don't need you again. They have to pay you. Or they call you to come to shift in the night and they say, sorry, can you come in the day? They have to pay you. So the employer must pay the employee for any shift that is cancelled, for any shift that is moved, or for any shift that is curtailed. That is your right under Section 3 of the Employment Right Act 2025. So an employer must make a payment of a specified amount to a worker each time that the employer cancels, moves, or curtails a shift on short notice. So if the cancellation or the removal cancellation or the moving or the curtailment is on short notice, then you have to pay the person for that. So that is called payment for inconvenience. So if you are going to inconvenience the employee by canceling shift or by moving shift or by curtailing shift, then you have to pay inconvenience allowance or make inconvenience payment to the employee. And that is Section 3 of the Employment Right Act 2025. Producer, let's go to Section 4. So Section 4, agency workers. Agency workers. So please take us to Section 4, agency workers. Agency workers, here it says that an agency worker is somebody who has a worker's contract or an arrangement with a work-finding agency by virtue of which the individual is and direction of another person. So by virtue of individual is supplied to work for another person or under the supervision of another person. We know what agency workers do. Somebody will employ you and give you to another person to work for them, and they take the money and pay you. That is the agency work pattern. But the law is that agency workers must have guaranteed hours and rights relating to shift. So if an agency worker, the agency cannot just call you whenever they need. They must give you guaranteed hours or guaranteed shift. And again, they have to ensure that your shift rights are protected. And that is quite good for agency workers. Remember, you can, once the phone lines are opened or activated, you can phone in to ask your question relating to the topic or relating to any question or any area of law at all. And the question, the number to dial, is 020 493 7345. That is the studio number. So the studio number is 0208 493 7345. 0208 493 7345. And the WhatsApp number for your questions. If you want to send your question directly by WhatsApp, the number is 073 99 208 468. 073 99 208 468. Again, you can send your message directly via the Facebook page, and we'll be able to pick it up and read and answer that for you. You are with Lawyer Charles of BWF Solicitors. We are discussing employment rights with respect to the Employment Rights Act 2025. What are your rights as somebody working in the UK? What can the employer do? What can the employer not do? We've understood that you have a right to guaranteed hours, and therefore 0 hours cannot be entertained any longer from next year. Again, you have right to notice if you are invited or you are called to work, that is shift, those on shift pattern. Again, you have to be paid if the employer cancels the shift on short notice or moves the shift on short notice or curtails the shift on short notice. Again, we have so far discovered that what you must know as a worker in the UK is that if an agency worker, the agency must give you guaranteed shift. They cannot just leave you hanging in a balance. I remember in time past when we were doing agency teaching, you just wake up in the morning, get ready, everything set, and the agency may call you or may not call you. You'll be there till 1 p.m. and the agency hasn't called you. You've wasted the whole day. That is not enough. Under the new law, the agent must give you guaranteed shift. It's not going to be get ready and wait for us. It has to be certain within a limited space of hours. So that's very important. So we are going to take a quick commercial break, and when we return, we take a couple more of the rights we have they will move into the minimum wage as well. Producer, we'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome to the show. You are through to the Community and the Law program. This is your authoritative legal program brought to you every Saturday by BWTV, proudly sponsored by BWF Solicitors, your community lawyers. If you are looking for BWF Solicitors, remember we are located at the 4th floor, Anna House, 214 to 218, the High Road, Tottenham, Seven Sisters Station, right at the underground subway. We are at the 4th floor of the Anna House. If you are traveling by the tube, that will be the Victoria line, all the way to whichever part you are coming from, but you have to alight or get off at Seven Sisters and follow the Tottenham Stadium location or the arrow that point to the Tottenham Stadium. That takes you right to the point where we are located. If you are coming by bus, either from Stamford Hill, from Edmonton, from any part of the world, of course, from any part of UK or London, again, if you are by the overground, you can get to South Tottenham train station, or you can get to Tottenham Hill train station, or you can get to Seven Sisters Overground train station, and you make your way to the Seven Sisters station where we are located, the Anna House. This program is brought to you every Saturday. Again, there are other programs that BWF Solicitors brings you on Thursdays and Fridays. So if you miss this one, you have a Friday or you have a Thursday, and we have diverse topics that we bring to you every week just to empower you, to help you, and to make you strong and hopeful that the law works for you. This afternoon, we are looking at your rights as an employee or somebody working in the UK. We know that there's a new law taking effect next year, and that is the Employment Rights Act 2025. We are discussing a couple of things that we must know as workers or employees in the UK. So, producer, please take us to Section 5. Section 5. Okay, so Section 5 deals with, okay, hold on. We don't need actually Section 5 because that is collective bargaining agreement for union. So for union, because we are discussing individuals, so we won't worry so much about collective agreement. Again, amendment relating to Section 1 to 5, we are not. So amendment relating to Section 1 to 5 will be your right, the contract that must be given to you, and so on and so forth. So let's touch up on that, please. Okay. Right. Right. So amendment relating to sections 1 to 5. So here it looks like certain things that have to be changed within the law that exists before this one. And here we're looking at agency worker. We are looking at specified. So here it says that agency worker has the definition within the rules. We are not going to go into technicalities. So obviously, if you have a case, these are some of the things that will be looked at, the interpretation. We are not going to look at the interpretation per se. So we go back to the table of content and move on to the ones that relate to us. Now we are looking at flexible working hours. So Section 9, flexible working hours. Flexible working hours. Right to request flexible working time. Flexible working time. So here it says that an employee or a worker has a right to request flexible working time. And flexible working time will mean that instead of full-time, you want to go part-time. And here the employer must accommodate that request. And it's a right under Section 9 of the Employment Rights Act. So you have a right to request for a flexible work pattern. Most employers will have this within their policies in the workplace, but it's now specified within the law that an employer must be open to an employee's request for flexible work. And the reasons could be on sickness grounds or on childcare grounds, family needs grounds, learning grounds, and so on and so forth. As long as it makes sense, of course, it's an agreement between the employer and the employee, and so the employee must make the request, and the employer must consider the request. We go to the next one, which is relevant to us as employees. So here we look at statutory sick pay, Section 10, statutory sick pay. So statutory sick pay, we know that once you are unwell, you have sick pay that accrues to you and the employer must pay. But the law now says that statutory sick pay in Great Britain, and here there is a removal of waiting period. The waiting period aspect has been removed. And what is the position now? Producer, please go down for us. So, okay, if you go back up to the beginning where it says that Part 11 of the Social Security Contributions and Benefits Act is amended as follows. And so here there is liability for employers as far as certain sections are concerned. Before, employees will have to wait for a certain period before they can benefit from statutory sick pay. But now that waiting period has been removed. We are not giving full education. We are giving pointers. And therefore, if you feel that you need to understand any of these things as far as your rights in the workplace are concerned, you have to seek advice further so that your specific need can be looked at and legal advice offered to you. So for today, we are just picking up all the key things we need to know as far as our rights are concerned as workers. So statutory sick pay is immediate. you don't have to wait for any period before you can request statutory sick pay. Let's move on to, so go back to the table of content, please. And we also look at, scroll down to entitlement to leave. So we're going to now look at leave. So leave, you have a right to be given leave to deal with certain things. And here we are clear that as an employee or somebody working in the UK, you are entitled to leave. Now, parental leave, there is removal of qualifying period of employment. So the qualifying period of employment has now been removed. So here, please just go up a little. Yeah, there. Yeah, so in section 76 of the Employment Rights Act 1996, there is a need for a period by which you can qualify for parental leave. That has been amended. And if we go further down to paternity leave, go to paternity leave. Producer, please just a little down, paternity leave. Okay, so paternity leave, again, removal of qualifying period of employment. Paternity leave, we know that if you are a father, you can ask for leave to enjoy or bond with your new baby or with a child born to you. And here there's no need for the qualifying period which existed before. And so certain aspects that restricted people from enjoying such rights have been removed. And so let's bear that in mind. Again, it's important that we seek full advice if anytime there is that we are exercising such right in the workplace, we have to seek full advice. Okay, producer, go to the next level of leave, please. Okay, so if you look at parental leave, we look at paternity leave, and we are looking at ability to take paternity leave following shared parental leave. Don't go. So don't, no, if you can go back, please. Some of them we can touch up from here. So there are people who can look at shared parental leave where they can swap certain, if I'm a dad and the woman is the one who is working full-time, bringing money home, then we can swap certain leave. The law makes provision for that. So ability to take paternity leave following shared parental leave. So after the shared parental leave, if you qualify for paternity leave, of course, you can exercise your right by taking leave. Bereavement leave. We know that if you are bereaved, you can take leave from work to mourn or to help with arrangement, burial, funeral, and so on and so forth. And so there's provision for that. Now, section 19 looks at review of extent of right to time off for public duties. We know public duties has to do with going on court duty. So if you are invited to appear in court to support a case as a member of the community, and we call these people the jury. So if you are asked to come for jury service or to go on jury service, we know that you have to be given time off to attend to that. That's the public duty. There could also be other public duties that you can be given leave from the workplace to attend. However, these are being reviewed further. And then we look at protection from harassment. Producer, please go section 20, protection from harassment. And this is key. There has been recent cases from the court which point to the fact that employers have a duty to ensure that employees are protected from harassment. And here, if you are working in the UK, that is your right. Employers to take all reasonable steps to prevent sexual harassment, and that is within the rules. If we go down to 20, scroll down, please, producer, scroll down to harassment by third parties. So harassment by third parties could be people who will come in to the workplace. They are not workers. They could be visitors. They could be clients, but they are third parties. And therefore, if these third parties end up harassing members of staff, then the employer must ensure that the right of the employee is protected in terms of protection from harassment by third parties. So there is a duty on the employer, and again, the employee has a right. Now, it says an employer must not permit a third party to harass a person who is an employee. For the purposes of this section, a permit, that is the employer permits a third party to harass the employee only if the third party harasses the employee in the course of the employee's employment. So if the employee is not at work or working at the time and somebody harasses that person, then that will not be the employer's duty. That is, and again, if the employer failed to take all reasonable steps to prevent the third party from harassing the employee, then that will be a breach of duty to protect that employee. So that is for employers and employees. Let's go down, producer, please, to any other level of protection. It says, okay, we've covered that. Can we go back to the page, please? There is one case, producer, let me mention this. There is a case that went to court, and the court it was within the social media, and somebody said that the person was fined I think £1,400 or so for calling somebody auntie. You know, a lot of people, depending on the background, they will call elderly women auntie and elderly men uncle. So if you call me uncle and I say, don't call me uncle, just call me Charles, and you keep calling me uncle, that will be harassment. Again, if you call auntie, and the person say, please, I don't feel comfortable by that name, don't call me auntie, and you keep calling auntie, whether you are so respectful or this or that, you keep calling the person auntie, that will be harassment. So in this case, the person took the matter to court, and this person who called this woman auntie was asked to pay a fine for harassing the colleague at work. So unfortunately, that is how petty harassment can be, but it is what it is. As long as the person says, I don't want it, you have to make sure that you don't. Producer, please take us, we take a couple of them, and when we come back, we take a commercial break and move on to something else. So we've covered protection from harassment. Please go down to dismissal. Yeah, dismissal. Section 25. So Section 25 deals with dismissal. Section 25 says that an employee has a right not to be unfairly dismissed. An employee has a right not to be unfairly dismissed, and the unfair dismissal, before, it has to be with a qualifying period. The qualifying period of 2 years under Section 108 of the Employment Rights Act has been removed. So Section 25 of the new law has removed how long you have to wait for you to bring a case under unfair dismissal or for unfair dismissal. And so if you work for 6 months, you can bring a case against the employer for unfair dismissal. And that is from, so then according to this law, from 1st of July 2026, if an employee start working or somebody start working from 1st of July 2026 up to 1st of January 2027, they would have qualified for that right not to be unfairly dismissed. And so 2 years qualifying period has changed to 6 months. And that is good news. So that is section 25. No more 2 years. It is now 6 months. So if, for example, a care worker who has worked with the employer for 7 months, and the employer says that we don't need you anymore. There's work, everything is fine, but they just don't want the employee, or for some error or mistake on the part of the employee, the care company says that we don't want you anymore, you are terminated. Before, the person cannot go to court because they have to work for 2 years. But now, from 1st of January 2027, they can go to court and sue for unfair dismissal. So that is good news for workers, and that is a right. Producer, please take us to the next one, back to the page. Yes, so we've covered 25. 26 deals with dismissal during pregnancy. Dismissal during pregnancy. And 20, so let's look at dismissal during pregnancy, please. So the law says that during pregnancy, you cannot dismiss the employee. And here we're looking at the fact that at the time the person is pregnant, obviously they may go on maternity leave. If they go on maternity leave, depending and with respect to certain aspect of this particular law and existing laws, it will not be fair for the person to be dismissed or to be made redundant simply because they went on maternity. So if somebody goes on maternity, their job will be there for them. Of course, if after the period of maternity or pregnancy, they do not wish to return, then that is a different matter. But during the period of pregnancy or maternity, they cannot be dismissed. Producer, please, let's go to the last one under dismissal, which is section 28. Let's go to 27, period of statutory family leave. So it says that dismissal following period of statutory family leave, where an employee has requested leave, either for paternity or for family or for whatever reason, they cannot be dismissed. They cannot be dismissed during that period of leave. So let's bear that in mind, that it's your right that during the time you are on leave for bereavement, for maternity, for paternity, or for what have you, compassionate grounds, the employer cannot dismiss you. And section 28, producer, section 28. So here we are looking at a right that a dismissal for failing to agree to variation of contract. So there are instances where the employer may say that I want to vary your contract. Oftentimes we give in, but this particular area or part of the law says that if you choose not to agree to certain variation of your contract, and on that basis the employer wishes to dismiss you, then it becomes an area for this law to look at. And what does the law say? An employee who is dismissed is to be regarded for the purposes of this part as unfairly dismissed if the employee was employed for the purposes of business carried out or carried on by the employer, and the reason for the dismissal is a reason within section 2 or section 3. We've covered those ones. But the reason within this section is that the employer ought to vary the employee's contract of employment to make a restricted variation. So where the employer decides to make certain restricted variations and the employee decide or not to agree or did not agree to that, the employer cannot dismiss the employee simply because they did not agree to variation of their contract. So let's bear that in mind. Right. On this note, we are going to take a commercial break. Once we return, we'll open the phone lines. All the lines will be activated. You can now phone in to ask your question. You can now send your messages, and you can now either dial or text, and we'll be glad to respond to your question. Question can vary on employment, on family, on immigration, on dispute resolution, on any area of law as far as your needs are concerned. So feel free, you are not restricted in any way. You are with the Community and the Law program this afternoon, brought to you proudly by BWTV and sponsored by BWF Solicited. This is your host and resource person, Lawyer Charles. We take a commercial break. Don't go far.
Client success. A skilled worker, dependent granted leave to remain despite his overstay. Case overview. Navigating a complex path to successful leave to remain. Our client was a dependent partner of a skilled worker with an initial leave to remain until 2027. Unfortunately, his partner's employer canceled her sponsorship. They both received a letter from the Home Office canceling their visas, which were due to expire in December 2024. His partner found a new sponsor who issued her a new QOS in December 2024 with 3-year sponsorship. She applied for further leave to remain before the end of the visa cancellation and was successful. Sadly, our client did not make his application. By the time we took his case, he had overstayed by 10 months. He explained that he didn't know he had to make a new application. The challenge: seeking to convince the Home Office to exercise its discretion in his favor. We made his application as soon as we received his instructions. We prepared a detailed cover letter to explain why the Home Office must exercise discretion in his favor, despite his having overstayed for more than 10 months. Our strategic approach for a successful application. We relied on the Home Office's discretion, explaining why he thought he didn't have to apply for further leave, although his wife had. We relied on the Home Office guidance and supported our representation with factors highlighted in the guidance notes. The updated Home Office guidance confirms that discretion may be exercised where the delay was beyond the applicant's control, or where the individual acted in good faith and has otherwise demonstrated compliance with immigration law. The outcome: granted 3 years leave to remain. Our client was granted 3 years leave to remain just a week after enrolling his biometric data. Takeaway: caseworkers may be able to exercise discretion under exceptional or compassionate circumstances where the application was submitted after the 14 days set out in exceptions for overstayers. You must always consult a lawyer when faced with such a complex issue. Facing complex immigration issues? Contact BWF Solicitors today.
Thank you for returning to the show. You are with the program, the Community and the Law. We have been discussing rights for those working in the UK as far as the Employment Rights Act 2025 is concerned. We have looked at key areas that are of importance to workers. We are now going to look at the minimum wage, and after which we'll point you to ACAS and also conclude with the fact that if for any reason you have to take action, the place to go to is the Employment Tribunal. So we look at the minimum wage for 2026. So the minimum wage for 2026 is, producer, please scroll down to the table. Scroll down. Oh no, on the right. Keep going down, keep going down, keep going down, keep going down. Yeah, that's the table. Yes. So we have the minimum wage for those under 21, those over 21, those doing voluntary work, and so on and so forth. So the national living wage for those aged 21 and above, and that is for most people, is now £12.71. £12.71. If you are somebody working and you are aged 18 to 20 years, your minimum wage is £10.85. If you are a teenager working aged 16 to 17, your minimum wage is £8. Again, if you're an apprentice, those working as apprentices whilst studying and all that, yours is £8. And accommodation offset. So there are people who may be having accommodation, but most people may not have this applying to them. So let's not worry about accommodation offset. But all we want to know is that if you're an adult working for an employer in the UK, the minimum wage has changed and it's now £12.71. And to know that, you just have to calculate to assess whether the rate you are on is exactly what the law says. If it is not, you have to have a conversation with your employer and remind the employer that the law says that the minimum wage is now £12.71. Right. Now we move on to, as an employee, if you are going through certain things, where or what can you resort to? In the first place, there are policies in place at the workplace. In the first instance, with your employer. But where you need to go further, you can also speak to ACAS. ACAS is the body that works for both employers and the employees. So, producer, so that is the ACAS website. ACAS, it says working for everyone, both workers and employers. So if you go to the website, they have advice session, they have dispute resolution session, they have a whole range of things that you can refer to understand your rights as a worker in the UK. So that is ACAS, ACAS. So this is just to point you directly. So we are not going to go further as far as ACAS provisions are concerned. Let's move on to, finally, if you decide to go to court, which court do you go to? Producer, which court can we go to? Employment Appeal Tribunal. So the Employment Appeal Tribunal, what do we do? It's all about making sure that they listen to your case and assist you by getting remedy or getting solution for that issue. Whether you are right or wrong, it's up to the court to make that determination. So and this is the last resort. First with the employer, through to ACAS before going to court. If you don't do that, then you may be missing the steps. It's always important that you have conversation with the employer at the workplace. Otherwise, the court will ask you to go back and get things done properly. Right. So we are now going to give you opportunity to phone in, opportunity for us to read your questions and to answer your questions. Remember, the phone line has already been shared on the page, and we are repeating that. So the studio number is 0200208593. Producer, the studio line. Please bring it again. So the studio line is 02. Oh, right. Thank you. So 0208597345, and the WhatsApp line is 0739920 208-468. Feel free to call. Feel free to send your message via the WhatsApp line, or feel free to share your message through the chat box, and we'll pick it up and read. Producer, do we have any question? Right. So the first question is coming from Emmanuel. Emmanuel says, does someone qualify when he earns 18,000 annually and also has savings of 12,000 in his bank account in the UK when it comes to the financial requirement for spousal application? So there is a rule for that. There's a rule, and you have to calculate it. So the rule is that you have to look at 16,000 plus, again, so 16,000 plus 29,000 into bracket the money you earn minus, so the money you earn times whatever it is that is the savings you have. There's a formula for that. And so if I have to confirm exactly whether the 12,000 you have and the amount you earn is possible to bring a dependent, we have to do the calculation. So Emmanuel Anyande, please, you have to get in touch so that we can calculate. As for the money is fixed, but the savings is whether it's enough or not is what you have to check. But I doubt if 12,000 is enough within the rule. So Zena says, is it possible if someone could give me time and date to contact? Yes, it is possible. So please, Zena, call us. Okay, call us after the show. We'll give you time and date to contact us. Or you can call us on Monday. Our office number, producer, can you share on the screen the office number? Our office number, so that Zenas can get in touch with us, and also the emergency contact number so that Zenas can get in touch. Producer, do we have the office number? So the office number is 0208 493 7340. 0208 493 7340. So Zenas, get in touch on Monday, book appointment with us, and we'll give you time to speak with us. Emergency contact is 077 1276 1884. 077 1276 1884, and that's emergency. If you are in Ghana and you want to speak to us through our Ghana office, the number is, of course, in that case, you have to dial directly. If you are in Ghana, is 055 055 589 5959. So 055 589 5959. Those in Accra, those in Ghana, those in Kumasi, those anywhere in Ghana, you can dial directly. If you are in the UK, you call us, the office number 0208 493 7340, and anywhere else on a mobile, emergency contact 077 1276 1884. So Zenas, that is the contact to reach us on. Evans is asking, what can I do if I suspect that my car registration number has been cloned? I have received a fine for an unpaid fuel, Okay, now, if you have received a fine, obviously you have to explain to them that you were not the one driving and that you were not available. If you are not available, where were you? How do you prove that you were somewhere else? So if you have evidence that you were somewhere else at the time the incident occurred, obviously somebody bought fuel at a particular time. The fuel station will have record of the time and the number plate. Then you can also confirm where you were at the time. Then we compare the two to see whether this was you or not. If not you, whether this is your car or not, then of course you can check with the DVLA as well whether this has been cloned. But if you say it's been cloned, then it becomes a forensic analysis matter. So it's difficult for anybody to say that this is cloned unless it is analyzed forensically. So Evans, first off, tell the people giving you the fine that you are not the one. Explain to them that you were away at the time and is the evidence. Explain to them that your car has been missing, or your car is not missing, but indeed you don't know why it happened. And let DVLA know that there has been, it appears that somebody has cloned your number plate, and let them look into it. That is all that we can share with you or tell you as far as your question is concerned for now. And this is coming through. I would appreciate help and ideas on how to go about adopting my late sister's child, who is 8 years old and a girl. I just started legal adoption in Congo, but I'm a bit confused. Should I pursue in the UK? I carry on with, okay. So our brother who has a question, the Congo and most other countries will have to, if you are adopting from any of such countries, it has to be the Hague adoption process, what we call the International Adoption Process, the Hague Convention. So the UN has prescribed the way people must adopt children, and UK has subscribed to that. And so if you're adopting a child from Congo, you have to start from the UK. So what I will say to you is that go to the council where you live, the borough where you live, go to the council and tell them that you want to adopt a child from Congo. They will refer you to the Children's Department or Social Services Department. Explain to them what you want. They will take the details, they will take you through the process, and step by step, once you finish the process in the UK, you get a certificate, DFE number of adoption, and the certificate will confirm that by today or on this date, the adoption has completed in the UK. You then use that to start the process in Congo, in the court there. And once you finish the process also in Congo, you have two: the UK confirmation and Congo confirmation, making it a complete process. So the rule is that where the child is coming to stay, which is the UK, get the adoption certificate from here. And where the child is coming from, which is Congo, get adoption order or certificate from there. And both are the things you need to confirm that you are the adopted parent of this child. And once you have become the adopted parent, you then go through the migration process to bring your child to the UK. Right. Any more question? I think we've covered Evans. Good afternoon. Good afternoon to Mumin. Okay, so let's go. So let's go to the platform and look at people who have who are on. So Citizen Kwajo is saying that please go back to the messages, the first two. Yes, so Mumin is saying good afternoon. Good afternoon, Mumin. And good afternoon to everybody who has joined us. And thank you to all those who have shared. And we encourage the rest of us to share as well. Ohima Mercy is asking everybody to share. And she says, share, and repost. We hear you, Ohima. Rebecca Mwakun says, good afternoon, everyone. Good afternoon, Rebecca. Good afternoon, wherever you are. Citizen is saying, good day, Lawyer Charles and viewers. Good day. Citizen Kwajo, thank you for watching. Sandra Fraser, our own Sandra Fraser, our brand ambassador. Sandra is saying, good afternoon, or please share when you join. Thank you, Sandra. Susan Kojo is asking a question. AA, That's the name. AA has held pre-settled status since 2020, and this is due to expire in 2026. However, she has a 2-year break in her continuous residence. Does this break affect her renewal, and will it be automatically renewed? If she decides not to do anything, it will be automatically renewed. And the 2 years is not an issue any longer. So our friend is okay. Here's the next question, producer. We have Chira Nancy. All right, so we have Nana Chiahini. Please, regarding paternity, maternity leave, does it mean that if one get a permanent employment contract and start working and for just 1 month give birth, they can request for paternity or maternity leave? It's all based on the circumstances, but of course, you are an employee, of course, I mean, the fact that obviously before you were hired, you were pregnant. So the employer was expecting that you'll be going on maternity very soon anyway, and therefore it's not a surprise to the employer. But the rules say that you qualify for maternity leave as far as you are an employee, and the waiting period or the qualifying period are the things that the employer will have to look at. So our friend, I don't know whether, so Nana, I know you're asking the question for somebody, but this person will have to then discuss the entire context of the situation with a lawyer or an advisor so that full advice can be offered. But as far as the rules are concerned, that is within the person's right, but it has to be looked further into. Papa Jari says certain amount of how much. I think it was respect to if the employer cancels shift. If the employer cancels shift or moves shift or curtail shift of the agency worker or the employee who is on 0-hour contract, they must compensate. By how much is within the context. So that is where the employer will look at the reasonable amount. So the law will have to remember we're just touching up on specific things. If somebody has a particular issue of this nature, the person will seek full legal advice as to how much money can I request from my employer for it to be fair compensation. And again, you also have to be mindful. You want compensation, you want to work for the employer, so it is situated within the limit of the rules and what is reasonable. So it's a matter of discussion to be able to ascertain what is relevant or necessary. There is a calculation for that ought to be looked at. So Papa Jari, that is what we'll say to that question. I'm in need of consultation with a solicitor. Kindly assist. Elizabeth Enchua, please get in touch with us. Get in touch with us. The number to dial is 0208 493 7340. 0208 493 7340. Get in touch on Monday and book appointment to speak to a solicitor. Asiedu Alexander Apia says, good afternoon to you all. Good afternoon to you, Asiedu. Good afternoon. Frank Akon, hi lawyer. If my son is 22 years old and I have indefinite leave to remain, what ways can I bring him to the UK? There's no way of bringing your son, unless, of course, you are a national of EU. So Frank Manesse Akon, do you hold EU nationality? If you hold EU nationality, then of course, you can apply to bring your child who is 22 years old. In this case, your child must show that he or she depends, it's a son, so he depends on you for living needs. But if you have indefinite leave to remain and you hold a foreign passport that is not EU passport, you cannot bring a child who is over 18. So we take a quick commercial break. When we return, we bring you the rest of answers to the questions. Don't go far. Stay put.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back to the show, The Community and the Law, brought to you by BWTV and proudly sponsored by BWF Solicitors. BWF Solicitors is your community lawyers. We are located at the 4th floor of Anna House, 214 to 218 High Road, Tottenham, Seven Sisters Station. Our postcode is N15 4NP, November 15 for November Papa. If you are traveling to see us by the tube, you come by the Victoria line and you alight at Seven Sisters. Once you get off, follow the arrows towards the Tottenham Stadium. Once you get up to the main road, you see our building located. Call us that you are now here and we will usher you in, or you follow the postcode to where we are. We will be waiting to receive you. If you are traveling by the overground train, you can get to South Tottenham, you can get to Seven Sisters, and you can get to Tottenham Hill stations. If you are traveling by bus, buses going to Edmonton, buses going to London Bridge from North London, you alight at Seven Sisters Station. We are right there. We offer all sort of help as far as the law is concerned: immigration, family law, probate, and general legal services. We are your preferred lawyers as far as immigration is concerned, as far as family matters are concerned: child arrangement, divorce, post-divorce matters, probate, wills, administration of estate, and so on and so forth. Again, contractual breaches, DBS cases and anything as far as the law is concerned, knock on our door and we will gladly assist you. That is BWF Solicitors. Yes, producer, please, who else is asking a question? So that is our scenario. Amma came to the UK on a student visa and later switched to a care visa. She got in touch with her uncle, whom she originally knew he was living in Germany, but now settled in the UK. Amma has been living with him for about a year, receiving support, especially after facing some medical challenges. Recently, her employer cancelled her visa because she is unable to work due to her health condition. Can she now rely on her uncle to support or to apply to remain in the UK? If the uncle is uncle in Roma, so this uncle, is it? So uncle. So since this is the uncle, not the parent, Amma cannot apply to remain with her uncle because uncle is an extended family member. Extended family member rules ended in 2020, December 31st. And so, unfortunately, even though Amma has a relative who is an EU national living in the UK and looks after Amma, Amma cannot apply to remain with this relative because this relative is not Amma's child, or this relative is not Amma's father, or this relative is not Amma's mom or step parent or grandparent. And so Amma cannot apply to remain with her uncle under EU rules. Patrick is asking, can you challenge visit visa refusal with no right of appeal? Yes, you can if your family member was the one who was refused. So if this is a family member refusal, you can appeal on, actually, you can seek judicial review. There's no right of appeal and there's no administrative review right, but there is judicial review right that is automatic. So you can assert your right under judicial review, provided there's human right element. And the human right is on the basis that your family member has been denied access to you by way of application for visa to visit you. That's the only way you can win at judicial review. So my visit visa has been unreasonably delayed. I sent PAP. On the 90th day, they said additional time is needed to conclude the PAP. My MP got involved. It's 121 days now. Does it mean it will be refused? It doesn't mean it will be refused, and it doesn't mean it will be granted. It simply means that they are not ready to make a decision. So if you prefer, keep chasing them until they give up on you to make a decision. But whatever is happening will not determine the outcome. The outcome is simply based on paragraph V4.2 to V4.6 of Appendix Visitors, which tells that anybody who is making an application to enter the UK as a visitor must show that they are genuine visitors intending to enter the UK with a view to leave. And therefore, if they are not able to prove that they will return to their country of origin, the visa may be refused. So this is from Kwame Louise. Please, I made an application for my wife and daughter. The Home Office wrote to me to provide the following requirement for dependent child of a skilled worker. Okay, Yeah, go on, producer. What else? Is that all? Right. Kwame Louise, is that all? You are just quoting the law. We know the law. So what else? What's the issue? Okay. So Kwame will come later with the second part of the of the things, which is the question itself. Okay, any more question from the page? Again, you can phone in to ask your question. This is from Elizabeth. I'm currently looking for a new job with sponsorship. What do I do? Keep looking, keep applying. Go online and look for the list of sponsorship license holders, or so a list of companies with sponsorship license. You get the list, go through them and make applications to as many as you can. Who knows, you may succeed. Right, so we are now going to the nugget where we assess. Oh, he came back. He's just quoting the law, This is still the law. Kwame Lewis is just quoting the law. I think he's just giving us what the Home Office gave him, but we know the law. Yeah, Appendix Children, paragraph 3.1, 3.2, and all that, we know. So, Kwame Lewis, come with your question, okay? Tell us what your question is. So the nugget is that verbal resignation may not be resignation. Employers must always consider the context of an employee's resignation before construing it as intended. If it is retracted, it must be seriously considered. The recipient of the resignation should, in the eyes of the reasonable bystander, consider that the resignation was seriously meant, really intended, or conscious and rational. Failure to consider the circumstances of the resignation may lead to unfair dismissal. And this is the case of Omar versus Epping Forest District Citizens Advice Bureau 2023. And it tells it clear that don't just say take no to be no, but understand how the no was said and why it was said and the nature of it before you can agree that no means no, and that is to employers. Otherwise, an employee who said no and later changed his or her mind can come back and say, you have unfairly dismissed me, even though I said no. Right. So this is a situation with Sedu. Sedu works for a care home as a carer. On the 1st of February 2025, he told his manager that he has had enough of the pressure at work and would not want to work anymore from the following day. The manager told him that since he didn't want the job, someone would take over his role. The next day, Sedu returned to work and explained to his manager that he was stressed and didn't mean what he said about quitting the job. The manager told him that, well, since you chose to leave, somebody else has taken up your role, and so you are no longer a staff. Sedu is worried. He said, but I didn't mean it. This is harsh. What should Sedu do? Give him advice as his legal advisor on employment matters within the nugget for today. So we are waiting to take your answers. So producer, we take a quick commercial break, and when we return, we take those answers.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specializing in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back to the show. So our brother Kwame Lewis comes back with the final part. What is it? The one, producer? So what do the Home Office need? Because I have provided birth certificate for my daughter and DNA test result. Well, I'm not sure the context because you haven't really told us anything. You haven't really said much. All that you have done is to give us the law, quoting the law, which we know already, my brother. And what did they say? What did they say? They did so. All right. And finally, what the Home Office? What do they need? So, Kwame Lewis, I think you need advice. Speak to a lawyer. Let the lawyer go through the request from the Home Office and work with you in terms of response to them. Because if it's about your child, it might be that it's about sole responsibility and not just the fact that the person is your child. What about the other parent? Is the other parent in the UK? Does the other parent also have a valid leave in the UK? If not, you have to show sole responsibility. So the law you quoted is in 3 parts. Either the other parent is dead, or you have sole responsibility, or there is serious and compelling family circumstances in the life of the child that makes their exclusion from the UK undesirable. Simply put, there are safeguarding concerns. If not, the application will be refused. So they are asking you to prove that maybe you have sole responsibility. So DNA doesn't prove sole responsibility. DNA proves that you are the parent, but what shows that the other parent cannot look after the child if you are here and the child is in that country with the other parent. So get in touch with the lawyer and speak to the lawyer, and let the lawyer go through the letter from the Home Office with you and to guide you through the best response. Okay? Right. Okay, yes. So we're now ready to take your answers. So the question was for us to advise Sedu. Nana Ajuman is saying B. I think you meant 2. Yes. So Nana Ajuman says 2. Sedu can bring action against the employer for unfair dismissal. Joseph Akole says it's 2. Thank you, Joseph. Thank you, Nana. Yes. Nana Safu says 2. Right, Nana Safu, thank you. Who else? Stephen Amankwa, I won't trust, says it's 1. And he says that Sedu cannot do anything against the employer because he chose to leave the job. Thank you, Stephen. Who else? And this is from Nana. Nana says, I agree with Stephen. Sedu cannot do anything. What else? Anybody else? Jemfi says, I agree with my 2 earlier colleagues. Yes, Sedu cannot do anything. Mami also agrees. Sedu cannot do anything. Nana Jebi, Nana Jebi says, well, Sedu can do something. As a matter of fact, Sedu can sue the employer for unfair dismissal. And this is from Gloria Tegaga. Gloria said that it's number one because Sedu cannot do anything because Sedu chose to quit the job. Who else? Akwesi Owusu in Kansas says that, well, even though Gloria said number one, I will go for number two. And I believe that Sedu can sue for unfair dismissal. Emmanuel agrees with Gloria and the rest who said it's one. Sedu cannot do anything. Equia from Poma says that, well, I agree with Nana JB. I'll go for two. Sedu can sue for unfair dismissal. Obed also says that Sedu can sue for unfair dismissal. Gifty Duakobua says it's number one. I agree with Gloria and all those who said it's one. Nana Pokia says one. I support those for one. Okay, I suppose that is all we have. Who else? Kwajo Tufuo says two. Kwajo says it's two. Kwajo says that I will help Sedu to go to court because he has a case against the employer for unfair dismissal. And who else? Anybody else? All? Okay, it's been a wonderful participation, actually. We've got fantastic students, and we seem to have a tie between those who said one and those who said two. So we go to the nugget, then we apply the law to the case. So what is the law? And this law is the case of Omar versus Epping Forest District Citizens Advice Bureau, 2023 Employment Appeals Tribunal. And here, the summary is that if an employee verbally resigns from work, in other words, verbally says that I don't want to work anymore, and later changes his or her mind by retracting that statement, the employer must consider the whole context, whether the person meant to resign or something was pushing the person to resign. And therefore, the assessment should be holistic. It has to be based on the reasonable bystander test by asking, what will somebody who has full knowledge of the situation also conclude? Would the person conclude that Sedu meant to resign or Sedu did not intend or mean to resign? If the reasonable bystander concludes that the person meant to resign, then the employer is right. If the reasonable bystander concludes that the person did not mean to resign, then the employer should have accepted their comeback. And therefore, if the employer did not accept, then the continuous no to the employee for coming back will be deemed as dismissal. And by not going through the process, the employee can take action against the employer for unfair dismissal. That is what the law says. And therefore, we apply to Sedu. So please zoom for Sedu. Sedu, what is the situation? Sedu said that I'm fed up, I'm leaving, and he leaves. 24 hours or within 24 hours, he comes back. Employer says, why are you back? I thought you said you don't want it anymore. And Sedu says, I was stressed. The nature of the work. I just don't know what came over me. You know what? I was only joking or whatever. So don't take me serious. And the employer said, well, since you left, we've brought somebody in. So as if the employer was waiting for the employee to leave so that somebody else will take over. Anyway, the employer must also protect his or her job. So somebody took over. But is it fair for the employer not to accept Sedu back? The law says that if it is intended that if Sedu intended to resign, then that is resignation. But if Sedu did not intend to resign and take steps to retract that resignation that was offered verbally, then the employer should consider whether this was seriously intended, actually intended, or not. If it is concluded that that was not actually intended, then the dismissal will not be fair. And so at this stage, Sedu has a right to go to court for interpretation and sue for unfair dismissal. That is the position of the law. The answer is 2. So the answer is 2. As we have explained, the case of Omar is clear, and therefore, if an employee brings resignation to you, the employer, if it is not in writing, then be careful, because verbal resignation can be retracted. And if it is retracted, the employer must assess the situation before accepting the retracted resignation or not. That is the position of law. All those who said, yes, that is the case. All those who said, no, that is number 1, then we say that, don't worry, better luck next time. We'll bring you another nugget on Monday for the whole week, and we'll look at it on Saturday. So stay put for the next nugget, and I'm sure you will be able to apply the law and give the client the best legal position as far as the particular law or rule is concerned. We take a quick commercial break. When we return, we wrap up and draw the curtain on to today's program. Quick commercial break. Hello, viewers and listeners. Today we looked at the rights of people working in the UK, and we specifically looked at the Employment Rights Act 2025. And this law came into what was made into law on the 18th of December 2025, and it's effective from 1st of January 2027. Now, the key areas we looked at covers agency staff, 0 hours contract, bereavement, maternity leave, paternity leave, and guaranteed hours. Now, what we'll tell you is that please go online and search the law, Employment Rights Act 2025, and go through so that you know where your rights lie to be able to assert them when necessary. We also looked at the minimum wage, and we understood that the minimum wage for adult is now £12.71. £12.71. The rest for teenagers, for apprentices, and so on and so forth differ from this. But this is the main one, £12.71. We also learned that ACAS, the body that supports employers and employees, is there for everybody. And therefore, if we're a worker in the UK, to be able to understand your right and to be able to assert your right, it's important that you always make reference to ACAS. You can find ACAS online. Just type ACAS. ACAS. The website opens, there are a lot of materials there, and you can familiarize yourself with that to be able to understand your rights as far as you are concerned if you are working in the UK. We discussed that if you have issue, you first have to discuss with the employer. But if that doesn't work out, you contact ACAS. And again, if it doesn't work out, you go to the Employment Tribunal. The Employment Tribunal, you can get their details online. You can get their details online. line, Employment Appeals Tribunal, EAT. So that is the conversation for this afternoon. This has been brought to you by BWF Solicitors, your community lawyers. If you are looking for BWF Solicitors, you can find us or locate us at the 4th floor, Anna House, 214 to 218, Tottenham High Road, N15 4NP, N15 4NP. We offer legal services in immigration, in family children, in family divorce proceedings, in family post-divorce matters. Again, we offer service in wills, in probate. We offer service in dispute resolution, be it contractual breaches, debt matters, or DBS cases. We deal with all that. In limited cases, we may look at employment matters. These are many things that we offer. Feel free to get in touch and we'll be happy to assist you. We will come your way once again on Thursday with the legal education, on Friday with another legal education, and Saturday with the community and the law. Until then, be good, be kind, be proud that you are part of the wider community and make positive contribution always. Thank you for your time. Thank you for joining. But let's say thank you to our proud sponsors, and that is BWF Solicitors. Again, we want to say thank you to the people who are behind the scenes making things happen, bringing you the show all the time. Our chief host, Brad Kweku, also from Pong. Again, we say thank you to Professor Adai, who is behind the scenes making all this happen, the producer, and the chief executive producer, that is BWF Solicitors, and all those who have been supportive of this, Padmore, Sheila, Pamela, Frank, and all the people who are making this happen. We say thank you. And to you, a very loyal member of the BWF family, we say thank you for your time, and we will meet again next week. Enjoy the weekend and have a fruitful coming week. Thank you.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.